looking at today's topic, the healthcare alphabet. And it's funny because whether in the medical field or the legal field, at least in my office, I know we use abbreviations all the time. So HCP, just like the screen says, HCP, LW, the MOLST, the most form. Of course, we hear DNR and DNI, but for a lot of people, it's just a jumble of information, a jumble of names, and they maybe knew what a DNR was, but not what a DNI was. So that's the purpose of today. Okay. First question, of course, is why is all this important as we get older, as we go through these issues? And the one word is incapacity. Things happen to us regardless of age, but things can happen. Could be accidents, could be some type of illness, procedure, old age, incapacity through dementia-related conditions. Even under anesthesia, okay? There can come a time when somebody else may need to make healthcare decisions for us or healthcare decisions with us. So that's why we're talking about this. If you're turning 65 this year, there's a 70% chance that you will need some type of long-term care. Long-term care means help with your activities of daily living, generally. On the cognitive side, it can mean help with supervision in those activities of daily living. 70% chance. And you need to have a plan set up before, God forbid, something like that occurs. Very honestly, every adult should have certain documents and planning in place. It does not have to be irrevocable trusts for different children, generation this and generation that. It all depends on circumstances. It could be a basic plan. For example, every adult over 18 years of age, I have 2 kids in college. They both have powers of attorney. They both have healthcare proxies. God forbid we have to make decisions and help with something. But from 18 and up, there should be planning documents and there should be what we call advance directives in place, okay? Now, the reason they should be done in advance is because you get to choose who's going to help and what are they going to help with. The alternative to planning in advance is what? It's a crisis. When you haven't planned in advance, when you're hit with a situation, and I can guarantee you, being in this elder care field for over 23 years, a financial crisis or a care crisis will always leave you with less options, will always be more stressful, and will always cost more money. So you want to avoid a crisis. And how do you do that? By handling it in advance. It covers every aspect of your life, but the one that I'm involved in is planning legally, planning financially, and planning for your elder care issues as you get older, okay? So we do not want the crisis. We want you to plan in advance. I think I've drilled that home enough. So thank you. Now, what is an advance directive? Well, it's primarily dealing with healthcare decision-making. You are choosing, you're making a directive as to who can help you in advance. 2/3, all right, 63% of Americans do not have an advance directive, all right? It is a directive where you, in advance, get to decide who's going to make healthcare decisions for you in the future. There are 2 main advance directives. The first one is called a living will, not a last will and testament, but a living will. And as I tell my clients too, not a living trust, it's a living will. And I know these terms get confusing. So we'll talk about a living will today because that's one of the advance directives. We'll also talk about the other, which is a healthcare proxy. So those are the 2 primary advance directives, all right? So let's get into them. In the alphabet, we have an HCP, and as I've shared, that's going to be the healthcare proxy. The healthcare proxy is where, under what's called public health law here in New York, and by the way, each state does have different terminology. In New York, we call it a healthcare proxy. In other states, they can call it a healthcare power of attorney, all right? In New York, the power of attorney is just for financial matters. For healthcare matters, we have a healthcare proxy. And the public health law in New York is what outlines the general form of what a healthcare proxy should look like. It's where you can appoint one person at a time to make healthcare decisions for you if you can't do it yourself, okay? So we've had children of our clients call us up and say, you know, mom was in the hospital and the nurse wouldn't talk to me. Okay, was mom still alert? Was mom still oriented? Did she still know what was going on? And the answer is yes. Well, if mom is still there, able to make decisions, the healthcare proxy document is not yet effective. It is only effective if the person who appointed you, your loved one, the principal, is unable to make the decisions themselves. Okay, that's when the healthcare proxy kicks in. In addition, another little quirk for some people is it's only one at a time. You cannot pick two agents. You can't pick two proxies to serve at the same time. Yes, I've seen it done incorrectly throughout the years, even forms done by attorneys. It's one of the reasons I think a form like this, even though it's available to the general public, should be prepared by an attorney that knows what they're doing, so that we'll follow the law and get it done properly. You can certainly have two people on the form, but you just have to have a primary and a contingent or a secondary, okay? When we do these forms for our clients, we'll typically name a spouse if that's the appropriate person to make the decision, and then a child, all right? There's your one and your two. In addition, the legal form, the way we do it, and other attorneys that know what they're doing, is we add language to it very minimally. We add one sentence, and the form, if you can picture the form in your head, there's a couple blank lines in the middle of this state-approved form. Those lines deal with whether or not your agent, your proxy, knows your wishes about artificial hydration and nutrition. And if you don't write that in there, then that agent will not have authority to make decisions about artificial hydration and nutrition. In other words, feeding tubes. So the form, even as put out by the state, has to be added to minimally, okay? In addition, on our healthcare proxy, we will add in more alphabet, HIPAA, that's our HIPAA form, and most of you out there know what that is. That stands for Health Insurance Portability and Accountability Act. It's the privacy rules that deal with what's called your PHI, your personal health information. That's when you go to the doctor's office and sign 10 forms in different colors, those are all releases and authorizations for the sharing of your personal health information and releasing the privacy aspect of it. So a HIPAA authorization, appointing a HIPAA representative, can be built into the healthcare proxy. Other than that sentence about artificial hydration and nutrition and the HIPAA, we do not add anything else to our healthcare proxy forms. It's the KISS principle. Just keep it simple, stupid. All right. We like to keep our healthcare forms as simple as possible. Doctors and nurses are awesome people, but they're very busy and they don't have a lot of time to read all of the 2-3 page proxies that I've had clients bring in from other attorneys. You want to keep things simple, okay? Now, next advanced directive, commonly accepted advanced directive, is what we call a living will. Now, the living will does not have what's called a statutory form, unlike the healthcare proxy. The healthcare proxy, as I said, is under the public health law. There is no New York State enacted law creating a living will. A living will is what's created by common law or by case law. So there was a case in Westchester County dealing with an end-of-life issue. And the judge had said it would have been better for the parties had the person in question signed a, quote, living will. A living will is generally understood to be directions about end-of-life care, end-of-life medical treatments. And so what our form says, and it's pretty common with other attorneys, again, that know what they're doing, is that it states, if I'm in an irreversible or incurable condition, I do not wish to have any medical treatments that merely prolong the dying process. Then it says, no ventilators, respirators, feeding tubes, dialysis, antibiotics, etc. No medical treatments. But our form says I do wish to have pain relief, maximum pain relief. Some attorneys and some organizations put in their living will, I want pain relief even if it hastens my death. And you may have a form that says that. I don't like that phrase, and I talk to clients about it usually. It certainly can be put in if that's what the client wants, but I just don't throw that out there as an automatic. We want to say no to these treatments, and we want to say yes to comfort and pain relief. My opinion is I don't want to give the green light for too much morphine to kind of end things prematurely. But again, as an attorney, I do what the clients want and what their wishes are. All I could do is give options, okay? Now, a living will does not appoint anybody. It's just a statement about end-of-life care. It is dealing with medical treatments. As I share with clients, it is not about 911 stuff. A living will is not about, God forbid, accidents, heart attacks, strokes. EMS will show up, they will stabilize, they will get you to the hospital, okay? The living will is for in-hospital, it's for in-facility care. Once there's been a determination that you are no longer going to be surviving or what they call actively dying. And it's a statement that if I'm at that point of no return, I do not want to have these medical treatments to keep me alive artificially. Just let me go. All right, so that's the purpose of the living will. You do not have to have a living will. I would recommend you have a healthcare proxy always. And just to, give you my opinion on that, I think the healthcare proxy is the best way to deal with these issues. That's a living, breathing person that you can communicate with in advance, right? There's that word again, in advance, so they understand your wishes. To me, that's always better than a piece of paper. But the living will is essential evidence that the healthcare proxy agent can use if that healthcare agent finds you in a predicament having to make a decision about end-of-life treatments, okay? Now, we always do, come on, what are we doing here? There we go. We always do the living will and the healthcare proxy as two separate forms. Reason being, number one, is that's how the statute, remember, New York created the healthcare proxy as a standalone form. A lot of attorneys do meld the two forms together. So it'll say, I appoint my spouse to make my healthcare decisions. And by the way, if you find me in this condition, I do not wish to have any medical treatments that will prolong the dying process. That's fine for some people if they want it to be laid out that way. My preference and the way I lay it out for clients is we do two separate documents. To me, I believe it just gives the healthcare agent a little bit more control over the situation, in that if your loved one that you are appointed their proxy is going to a facility, going for a procedure, you give them the healthcare proxy. You're there to make decisions. You leave the living will at home, all right? Whereas if it's all in one form, you are giving that form, it's going in the chart. Whatever the nurses and doctors, again, as amazing as they are, do with that information, it may be premature. It may not be time for even the living will discussions, yet it's already in your chart. So again, I like it as two separate forms, and that's how we lay it out for clients, okay? Now, let's get into those, again, being the advanced directives. Let's get into more of the medical terms that you see. Now, the first one to cover is probably the most common one that we see. It's what's called a DNR. And of course, that stands for do not resuscitate. It can be considered an advanced directive. Bottom line is that the hospital will certainly try to help any patient whose heart has stopped or who has stopped breathing. And they do that with, we all know, CPR, right? Cardiopulmonary resuscitation. The DNR, do not resuscitate, is a request to not have CPR if your heart stops or if you stop breathing, okay? That's it. A DNR prevents CPR, okay? The DNR is not a living will, and a living will is not a DNR. All clients say it all the time when we start talking about living wills and consults. Well, they go, oh, the DNR. Right church, wrong pew. It is the right topic, so we talk about that. But the living will is the legal form. The DNR is a written medical order from your physician saying no CPR, okay? It's a discussion for you and your doctor, or for you and the proxy to have based on prior advanced, there's that word again, discussions, okay? It's typically within a hospital or a facility. That's where the DNR lasts and survives. There is also what's called an out-of-hospital DNR for the community, all right? Again, talk to your doctor about those circumstances if that's what's appropriate for you down the road, all right? Now, then there's something called DNI. I will tell you, over the last year and a half, I've heard about intubation more than I've ever wanted to, and more than I ever thought I would, and I'm sure that goes for all of us. A DNI is a do not intubate order, okay? It should be happening, that type of discussion and decision should be happening at the same time that people are talking about DNRs. During intubation, a doctor will insert a flexible plastic tube through the nose or the mouth into the trachea, the windpipe, to help with the breathing. You may be under a medically induced coma at that point, okay? The tube is connected to a machine called a ventilator, another word that we've heard, unfortunately, way too much over the last year and a half. And that ventilator, as we've all come to know, will push air and oxygen into your lungs, okay? I've been told by doctors that the DNR and the DNI are separate because you can actually have trouble breathing before your heartbeat or breathing stops, okay? If your breathing problems continue, your heart or lungs may go into full cardiac arrest, and then and that intubation that we're talking about here can reduce the chances of cardiac or respiratory arrest. So the DNI can be used at different times, all right? So it is an important conversation to have, all right? Again, the use of intubation may prevent or stave off cardiac arrest and respiratory arrest. So it's important, again, these aren't discussions with your lawyer. These are discussions with your doctor. I'm here to just kind of frame out and kind of reiterate what you may hear from them or from your own research. Now, the DNR, DNI conversation. I've spoken with many police, many EMS, many doctors. There's pros and cons to CPR. There's a statistic out there. In-hospital CPR results in about 25% success rate, if you will, okay? So you need to know that CPR in a hospital doesn't always work. CPR anywhere doesn't always work, all right? Again, I'm just trying to give information so you can have those conversations. It's also important to know that if it's just breathing issues, respiratory issues, that at least 60% of those survive with the intubation. So you might say no DNR, but yes to DNI, okay? Each circumstance and each person is going to be different, okay? Now, let's mention another medical term, okay? The idea of a full code. A full code means that you do not want DNR and a DNI. You do not want those orders. It means you do want any electrical shock or chest compressions, and you do want intubation, okay? Again, so a full code means you do not want the DNR order and you do not want the DNI order. It means you do want the electrical shock and chest compressions, okay? Again, just file that away so that when you do talk to your doctor, you'll have that, that topic and be able to talk about it a little bit. Now, an interesting other topic we'll talk about is what's called a MOLST, M-O-L-S-T. The advanced directives of healthcare proxy and living will, the medical forms of DNR and DNI, all important knowledge to have. This is another world right now, M-O-L-S-T, MOLST form. It stands for, let me click my button here, medical orders for life-sustaining treatment, okay? Medical orders for life-sustaining treatment, there's your M-O-L-S-T. Why is it pink, Brian? Well, because it is a bright, bright pink form. The New York State came out with their own MOLST form a number of years ago. Other states call it a POLST form, P-O-L-S-T. And I'm sure some of you got it already. That stands for physician orders for life-sustaining treatment. Again, New York with MOLST, the medical orders. It's meant for those with an advanced illness who might pass away within 12 months. That's generally what it says. Or somebody that may require long-term care services in a skilled nursing facility, for example, and they want to document their life-sustaining treatments like the ones we've been talking about, okay? It's not a legal form. It's not something we help with. It's where your loved one or you yourself have a conversation with your doctor or RN or physician assistant or nurse practitioner to complete this form. This is an active medical order. It is not like a DNR that stays within the facility, okay? It's a bright pink form so that it stands out no matter where you are, it can be grabbed. So if you're in a hospital, it should be on your chart. If you're in a nursing home, it should be on the wall or in the chart. Ambulance, it should be with them in the ambulance. Some people put it on their refrigerator, okay? So in case EMS is called and something's going on there. So it is an active medical order that continues, all right? It does not have to be renewed. It should be reviewed, of course, but it does not have to be renewed, okay? It will cover DNR questions and DNI and life support and ventilators and living will concerns. But as I shared before, I love having an empowered healthcare proxy agent that can actually have conversations because they know you and they know what you want and what you don't want, okay? I will admit when most first came out, I was not a big fan. Why? Because I like that healthcare proxy. But what I have found in talking to clients throughout the years, and I've been doing this work for 23 years, so it's a lot of families have come through our doors here gratefully, and I thank God we've been able to help them. Again, I like the healthcare proxy. I like the family to be involved. I don't like a static written form. What I do really appreciate about the most form lately, over the last couple of years, is that it allows the conversations to occur. And again, one of the themes about this is talking about things in advance. So if this form serves as that conversation to get your loved one thinking, to get yourself thinking about the different issues and concerns, this is a great way to do it. Another unofficial way is what's called 5 wishes. Next time I do this, I'll be sure to get that in there if I can remember. 5 wishes, you can find it online. Deals with who's going to help me make decisions, what do I want, what do I don't want, where do I want to be, etc. And it's, again, the main purpose for me is not to replace a New York healthcare proxy and a New York living will and a New York most form. It is there for conversation purposes, okay? If you have an aging loved one or you yourself are dealing with different health issues and age concerns, start to think about these things. Bring in your family or your trusted friends to help go through these concerns so it's in writing. See an attorney like myself, okay? And we will help put it together in writing as a part of an estate plan, okay? So again, most form, important, bright pink if you've seen it. Again, it's not something we help fill out, but it certainly serves a purpose. Now, as I've said in the beginning, these types of documents, these types of issues need to be discussed, I know, in advance. I'm sounding like a broken record at this point. But you want to talk to somebody that knows what they're doing. Don't call up, well, I don't want to put it that way. You're better served by dealing with an estate planning attorney. You're better served by dealing with an elder law attorney. You're better served in dealing with somebody like us who are elder care attorneys. We focus on the care issues tremendously. We have geriatric social workers on staff to help our life care planning clients through these issues, to help our life care planning clients and their caregivers make these decisions. So this is what we are very much so in tune with, all right? A man who does not plan long ahead will find trouble at his door. And one of our purposes and one of our missions is to help our families take care of these issues in advance. All right, you got a nice little picture there. Now that's an old binder, but that's one of our binders with all of our documents in there once we put things together. When we meet with clients, there's 3 services that we do. And all 3 of those services include advanced directives, okay? So even the most basic of plans for a healthy 25-year-old is going to have a healthcare proxy and a living will if they want it. So when we put together estate plans, from 18 to 118, we will always have 4 basic documents. First 2, healthcare proxy, living will. And then, of course, what's called the last will and testament. And then what may be a very, very, almost most important document on the financial side is what's called a durable modified power of attorney. So an estate plan, we do them every day of the week for folks varying ages, younger folks, older folks, good health, not so good health. The next service we provide is what we call an elder care protection plan. And guess what? It includes these advanced directives. It includes conversations about them because they're so critical. But the elder care protection plan, as the title kind of gives away, is for folks that are a little bit older. What I like to say is when you get your Medicare card, you should have your elder care protection plan. 65 and above is when we're talking about starting to protect assets with the potential idea of dealing with long-term care down the road. So an elder care protection plan revolves around irrevocable trusts typically and asset protection. We want to shelter that home. We want to shelter those non-retirement assets, okay? Now, we also do revocable trusts a lot, which are more of the probate avoidance, non-asset protection, but those would be in the first category of the estate plan. Now, the third main service that we provide on the care side, on the planning side, is life care planning. I mentioned it a brief moment ago. This is where my attorneys, my paralegals, and our elder care coordinators come together as one cohesive team to help your loved one navigate the elder care continuum. We support that senior, that loved one, decision-making, coordination of care, coordination of benefits, advocacy every step of the way, attending assessments, care planning meetings. It is the most comprehensive way, very honestly, to help your loved one deal with aging, asset protection, elder care issues, Medicaid benefits, and navigating the long-term care system, okay? It's a very unique service, and it's the one that we employ when we have our clients faced with care issues and the need for long-term care, okay? And of course, it includes our advanced directives. It's been a pleasure again to share this with you today. If there are any questions whatsoever about healthcare advanced directives, about irrevocable trusts, revocable trusts, our comprehensive life care service, if your loved one needs Medicaid and long-term care, we're here to help. Please give us a call. It is a free consultation. You can even email me directly if you'd like, Brian, B-R-I-A-N, at tullyelderlaw.com, T-U-L-L-Y, elderlaw.com. All right, phone number 631-424-2800. That's for those of you that are on the phone, if you're not watching the PowerPoint. Okay, let me see if we have questions. Okay, please explain. Okay, so please explain a feeding tube. First thing I'll say, Sandy, and it's nice to see you on here, is that it's certainly a best served to deal with a physician and a nurse on these issues. What you're looking at is there may come a time when a loved one is unable to either physically chew or swallow, and there's a need for food and nutrition, artificial hydration and nutrition, to enter the system. And it's typically done through a tube or a peg through the abdomen. The hope is that that is something temporary. If it is longer or on the permanent side, then there's other more serious conditions happening. But it is purely there as a temporary, initially, method to provide the artificial hydration and nutrition. Again, if there's a lack of capacity, you need that sentence in the healthcare proxy form for your healthcare proxy agent to be able to make decisions. Do we do a healthcare? Do we do a feeding tube or do we not? It's been going on for a month. Do we withdraw it? Those are issues that your healthcare proxy agent can decide upon as long as that authority is given in the healthcare proxy form itself. Other questions? What decisions require a doctor's order as opposed to a request in the living will? Good question. So the living will is a general statement. It is not a medical order. A medical order such as a MOST or a DNR or a DNI must be signed by a medical physician or nurse or NP and how that works. So the living will itself is a statement that if I'm in this condition, I'm not coming back. I'm at that point of no return. I do not want, it's a request, I do not want feeding tubes, ventilators, respirators, etc., but I do want maximum pain relief. Different again than the than the DNR. So to answer the question specifically, I think you're looking at the issue of CPR and the issue of ventilators. That's specifically going to have to come from a doctor. The way it does work, practically speaking, though, is if the healthcare proxy agent is employed, they are trying to make decisions. The doctor can turn to the proxy and say, what did Mr. Smith want? And that's where the proxy then picks up the living will and says, this, he did not want A, B, and C. And then a discussion occurs. Are we at that point where we can employ this actual document, use this document, rely on this document? All right, hope that helps. Okay, good question, Cindy. Can you please describe what happens when there are no advance directives? What's the hierarchy of authority for the family? So, great question. I should have brought it up, and I'm sorry I didn't. So in New York, we do have, gratefully, and it's only about 10 years old, what's called the Family Healthcare Decisions Act. That is where New York states that if there is no healthcare proxy in writing, that a hierarchy is able to make decisions. A person in that hierarchy is able to make decisions. It's going to be spouse and then children. Without children, then you get into partners, then you get into siblings or parents. The order is written out in the law, Family Healthcare Decisions Act. Yes, that's helpful in a crisis. Again, remember, I've been really pushing, maybe to bring it up because I've been focusing on this advance aspect. The reason a healthcare proxy is better than relying on that law is because you get to pick and you get to say in your living will what you want and what you don't want. In fact, really what you don't want. The healthcare proxy to me is a benefit because you could say spouse first, or you could say my middle child is the best one to make these decisions. Yeah, I have an older child and yeah, I have a spouse, but that middle child is a physician. I want them to do it. So the healthcare proxy lets you pick. Okay, that's why I think that's better to do. Last question I think here is if you are, there's another one. If you are also a power of attorney, can you also be the healthcare proxy agent? And the answer is yes. And you raise a good point there. When I talk to families and clients, these are not emotional, they should not be, try not to let them be emotional decisions. By that I mean, you don't pick your eldest just because she's the eldest or he's the eldest. You pick the best one to do the job. They're business decisions is how I phrase it. Although I understand there's a lot of emotion tied to them, of course. So it's not just about, and honestly, even if you have a physician as a child, that may not be the best person to pick. You want to pick the best person that you believe is going to fulfill the role. If it's a power of attorney, you want somebody who's financially astute, who's disciplined, who's responsible, who pays their own bills on time, hasn't lost the house in bankruptcy, isn't in the middle of a creditor lawsuit. You want somebody that is financially responsible to handle your power of attorney duties, as well as your fiduciary duties like executorships and trusteeship. On the healthcare side, perhaps you want somebody that's a little more assertive. You want somebody that's going to push the doctor or the nurse respectfully for answers and options and conditions and consequences. So you want to pick the right person. Can it be the same person? Absolutely, yes. But sometimes it's not, okay? Because you can see different personalities financially and healthcare-wise. Okay. If you have a feeding tube, can it be removed by family without doctor's permission? As our last question, I'm going to... Technically, I don't think that should be removed without doctor's permission. I think you might be facing even criminal charges. My goodness, that is a tough question. Depending on the environment, depending on the circumstances, if that's in there to keep that person alive and that's removed, I think that that's a real complicated issue. So I do not think, my advice, of course, would be to a family member, do not remove a feeding tube, same thing as a ventilator, without, right, because that's keeping the person sustained and alive, without medical direction, right? And don't even do it. Let the medical team do it. Okay, so that would be my input on that. A real pleasure being here again today. Thank you again. Feel free. Any questions? We're here to help. Free consultations. Younger folks in planning. 65 and above, asset protection work as we get older, thinking about long-term care, and of course, for those that require care, we're here to help our clients really get the best care possible. So thank you, and enjoy the rest of your week. Here we go. Bye-bye.